Hello and welcome back to another video for OCR A-Level Law. Today we're going to be looking at legislation on the OCR specification. So the first thing I want to cover is what you need to know for this topic. So you need to know the legislative process, you need to look at the different types of bills, and you need to be able to look at the advantages and disadvantages of the legislative process, which would obviously be a 12 marker, with the legislative process and types of bills being potential 8 markers. Just some background first before we start. This isn't directly examined, but something that you should be aware of. So obviously there are different types of legislation. We're talking about primary legislation here. So there are other names for primary legislation: Acts of Parliament, Acts more generally, statutes. They're all the same thing. So just different methods of saying the same thing. Bills are different. So bills are acts of parliament before they've actually gone through the legislative process. So a bill is a draft law or a draft statute or a draft act of parliament, and it's called a bill before it goes through the process. And whilst it's going through the process, it's called a bill. Obviously, it's good to know a bit of background here around Parliament. So Parliament is made up of two chambers, the House of Commons and the House of Lords. House of Commons you really generally recognise as the sort of green-seated chamber, House of Lords being the red-seated chamber. The House of Commons is made up of 650 MPs currently, and each MP represents a constituency. So for instance, Portsmouth, for instance, has two constituencies due to the population size, so Portsmouth North and Portsmouth South. Each of those has a MP. So in a general election, you vote in the election and you'll vote for your local MP in that constituency that you live in, and those you add up all of those MPs during the general election, and they make up the total 650 MPs that get elected to the House of Commons every sort of about 5 years. Now obviously there are different political parties: Labour, Conservative, Liberal Democrats, Labour and Conservative being the two biggest political parties. So they usually make up the government in some form, certainly have for a long period of time with a few exceptions. And the cabinet is the top sort of MPs in the government. So when you have a general election, whoever wins the majority of those MPs, so say Labour win 326 MPs, which would be just over half the total number of MPs, they would form the government as a majority government, and that's what it's called, a majority, because they've got a majority of the MPs. Sometimes you do get minority governments where they don't quite have enough, and usually they would join in some sort of coalition government where they join with another political party. That did happen in 2010 between the Conservatives and Liberal Democrats. Again, you don't need to get too caught up into this. It just gives you a sort of background before we go into the legislative process. So the cabinet is in the government. The cabinet are the top MPs. So you have all the MPs that are in charge of the different ministries. So Ministry of Justice, Department for Education, etc. Each will have an MP attached to them, and obviously the Prime Minister being the leader of the country as well, and the leading MP of the government. House of Lords is made up of unelected peers, so they're not elected in a general election. A number of them are there, hereditary peers are there because of their parents that were always a peer anyway, and then lots are appointed now as well, separately and independently. And also the Prime Minister can select a number of peers to be appointed to the House of Lords, and regularly does. And the idea of the House of Lords is to provide a sort of check and balance. And as I said, the government is the party who wins a general election. So it could be a majority government or a coalition government. So that just gives you a bit of background before we go into the actual process. As I said, you're not going to be examined directly on that, but it's a good idea to understand what those different institutions are, and the difference between like an MP, for instance, and the idea between the government and Parliament and the differences. People often use those names interchangeably, but obviously the government is a part of the Parliament, but they're not the same thing. So in terms of the first area you can get asked, the legislative process, I always learn this or teach this to my students as greedy white fat snails can't reach the handrails, and that gives you the name of each stage that you want to talk about. Now, in the exam, you could be asked for just the whole legislative process. They might name a specific stage and end stage. They might say from the first reading through to like the House of Lords. So just got to read the question really carefully and identify what from the legislative process they want you to include, if not all of it. The green paper and white paper are pre-legislative stages, so they happen right at the beginning. before actually the bill actually even gets into Parliament itself necessarily, or is at least put before Parliament. The Green Paper is the pre-legislative stage. It's about consultation, so they really setting out the main principles of the law and asking people what they think, so all sort of interested bodies. So for instance, the same-sex marriage bill or Green Paper went out and asked religious organisations, LGBTQIA organisations, about charities, about what do they think about this, what do they think about same-sex marriage, and also other interested parties as well. That's then pulled together into the white paper, which is also a pre-legislative stage, and this consolidates all of that information and firms up proposals of a new law, and usually includes a draft bill, so something that actually looks a bit more like an Act of Parliament as a draft bill. This then goes to the first reading, which is the title, which happens in usually the House of Commons. It can happen in the House of Lords, so the first reading can start in either chamber, but it usually starts in the House of Commons generally. And what they'll do is they'll literally read out the title of the new bill, the date of the second reading, and that's pretty much it. Now it's called the first reading, just a bit of history for you, because obviously this process was happening before mass publication or printing. So they used to obviously read the bill out in its entirety, and people would make notes or listen. So it's still called that. So actually, this stage is largely symbolic at the moment, but it gives people time to go away and read the bill, the Green Paper, White Paper, etc. Before the second reading. So first reading, they just read out the title of the new bill and the date of the second reading. Usually read out by the appropriate minister or MP. So if it's something to do with education, it would be done by the Minister of Education. Something to do with the NHS, Minister of Health, for instance. If it's really, really important, it might be the Prime Minister. But equally, if it's something from a particular MP, they might read it out. So it's done by that appropriate minister or MP. The second reading is really the main stage, I would say. They have a big debate on the main principles of the bill. So people will stand up and indicate that they want to talk, and you'll have seen this on the news probably. And the debates can last from anything from an afternoon to a couple of days, if not slightly longer. And then as part of this process, they will have a vote. So they actually vote with their feet, and that's not by pressing a pedal or anything fancy like that. It's literally getting up. They come out of the chamber, and there's two corridors on either side. They're basically a yes and a no chamber. They actually call them something slightly fancier than that. But it's essentially yes and no. And they will walk around and be counted in on either side. You can abstain, which means you just stay in the front, in the beginning sort of foyer area, and then just go back into the chamber. But essentially most people would either vote yes or no, and they then count up the yes and no's and then see whether it's passed a majority. Now it has to pass majority to progress. If it doesn't get a majority at this stage, it would be stuck here and wouldn't progress any further. And rarely do bills progress any further if they don't pass the second reading, although there are exceptions where they have. What will happen then is it will go to the committee stage, so a group of MPs or Lords, if it was starting in the House of Lords, but usually, as I said, it's starting in the House of Commons, a group of MPs will get together and they come up with amendments to the bill, so they really go through it with a fine-tooth comb, looking for issues, making suggestions of changes, which we call those amendments in the law. And that'll vary from 12 sort of MPs or Lords to potentially the whole House of Commons for very serious bills as well. So a bigger committee stage essentially. They'll then write those amendments up into a report, and that's distributed to MPs or Lords to read, and they'll go away and read that, and there'll be a gap of time obviously for people to do that. And then it goes to the third reading, and this is where the amendments to those bills are then debated. Now remember, in the second reading where the bill passed, that was the main principles of the bill, so it's not really saying yes or no to the whole bill in theory here. What it is actually discussing the amendments. So they'll have a debate again, and then moves to the voting stage in the same way as the second reading, and again it has to pass by a majority to progress. So it's unusual for the whole bill not to pass, but certainly amendments will be voted on in either yes or no and removed or added as they go. What will happen then is the bill will then go to the other chamber. Now usually, as I said, it starts in the House of Commons, so it would be moving across to the House of Lords, and it would then go through the same process starting from the first reading. So it wouldn't do the Green Paper and White Paper again, but it would go from the first reading through to the third reading in the other chamber, so in the House of Lords for instance. And then obviously they may come up with different amendments. So the House of Lords, for instance, might say, well, we think this would improve the law, this would improve the bill. So those amendments then have to be approved by the House of Commons, for instance. And this is known as ping pong. So it goes back and forth between the two houses until there's agreement on those amendments. Now, sometimes obviously they might say no. The House of Lords may say, well, we don't want to pass this bill at all, perhaps at the second reading. And ever since the Parliament Acts 1911, 1949, actually the House of Commons can force it through without the House of Lords permission. The House of Lords can delay it by a year. So, for instance, the Hunting Act 2004, they said, no, we're not passing it, and the House of Commons pushed it through. Had to wait a year and then pushed it through anyway. And finally, royal assent. This is where the monarch gives formal consent, so the king would give formal consent. This is largely symbolic now. So ever since the Royal Assent Act 1967, they don't see the whole acts really generally. So it's just largely a symbolic stage. And the last monarch to actually refuse was Queen Anne in 1707, which was the Scottish Militia Bill. So it's unlikely any monarch would refuse nowadays, although possible. In terms of types of bill, so this is another potential 8-mark question you could be asked. There is an older type called a hybrid bill, which you don't need to know, so that's not on here. So, but if you see that in any textbook and stuff, you don't need to know that on the current spec. So the three main bills here. The first one is a government bill. Now, the government bill and a private member's bill, they're both examples of public bills. Just to clarify that, public bills are bills that affect the public, clearly, so they're well named, whereas you can see a private bill underneath only applies or affects an individual company or organisation, so they are different in that regards. But a government bill and a private member's bill are both public bills, so you've got to be careful not to get confused here between private members' bills and private bills. So a government bill is a public bill, affects and applies to everybody in the country. It's created by the government, hence the name, and they're introduced usually by the relevant government minister or MP. So, for instance, the Human Rights Act was a government bill brought in by the Labour government based on a manifesto promise to basically bring in the European Convention of Human Rights and enshrine that in an Act of Parliament. Marriage Same-Sex Couples Act was a good example again of a government bill done by the Conservative and Lib Dem coalition to legalise same-sex marriage. And the Criminal Justice and Courts Act, which is another one you'll probably be familiar with on the specification as well, studying criminal law. Around juries as well, I think, actually. So private members' bills, they are, again, a public bill, so they affect and apply to everyone. They're created by an individual MP or peer, and that's the difference. They're not created by the government, they're created by an individual MP or peer. And they're usually introduced through either a ballot or through the 10-minute rule, which are different methods for introducing a private members' bill, essentially. A ballot, usually each session there'll be about 20 private members are selected to present a bill to Parliament, but they get very limited time to debate, and the government usually prioritises their bills, so very few of those actually become law. And then 10-minute rule, any MP can make a 10-minute speech to try and introduce a bill. So, for instance, the Bail Amendment Act was done that way as well. Good examples of private members' bills. One really famous one would be the Abortion Act, introduced by a man called David Steele, which obviously legalised abortion, and the Household Waste Recycling Act, which put a duty on local authorities, councils to recycle as well. So quite important for the environment and those sorts of things. Private bills, so as I said, these are different from private members' bills, but these apply or affect an individual, company or organisation. So they don't apply to the whole country or everyone in the same way as the two above. And the main example of this is one called the Faversham Oyster Fishery Company Bill in 2016, which was essentially to do with changing the way the company was run. So you don't need to know too much detail about it, but you can find the bill online if you want to have a look. So that sets out the information on that. Okay, and the final thing you need to look at is the advantages and disadvantages of the legislative process, which would likely come up as a 12 marker. So in terms of looking at these, I'm going to go through the advantage and then accompanying disadvantage for each one. So we're moving from left to right across the screen as we progress down the screen. So the first advantage of the legislative process is obviously it's highly democratic. The laws are made by elected representatives, being the MPs, so the House of Commons has very tight control around the legislative process in terms of they can force things through even if the House of Lords disagrees, for instance. They're all MPs who are elected by the people, the electorate, so they're therefore answerable to the electorate through general election. So if you don't like the laws that they've made through this legislative process, in theory you can elect them out and say, oh, I don't want to vote for you in the next election, so I don't like the law that you made. And then obviously that new body coming in, they can change the law back or remove that law if that was desired by the electorate, the public. So electorate is just another word for the public that can vote. So it's highly democratic in that regards. The bad thing, though, I would say here is, though, just moving across the disadvantage, is that the government highly control the process. So whilst you have all these elected MPs in Parliament, actually the government, especially if it's a majority government, they very much control the laws that are being passed. So yes, you might have all these Labour politicians or Lib Dem politicians, for instance, but actually they can have very little say during a government that's got a majority, because actually they can, if every MP votes for that majority each time for that government, they should be able to pass any laws they want, and any laws suggested by other parties shouldn't probably get through if the government opposed them. So the government is in very high control of it. They don't generally allow a lot of time for private members' bills, so whereas individual MPs are suggesting laws, although they do happen, as we talked about the Abortion Act previously by David Steele in 1967, and these private members' bills are often to do with sort of particular moral issues and things like that, but they get squeezed out by government time. So very, very few of those do become law. So yes, it is democratic, but actually the government, the specific MPs that make up the government, get the biggest say on the law. Now, obviously, in your area, you might have an MP that's not actually in the government, so your influence and certainly their influence of the legislative process and law might not be very strong, really, particularly if they're, for instance, we've got a Conservative government at the moment in 2023, and we're in June. If you've got a Labour politician or a Lib Dem politician or a Green politician, whoever politician MP in your area, they might not have very much say over the legislative process at the moment. So is it that democratic in that regards? Moving down to the advantage about full reform, one really good thing about this legislative process is that it can reform entire areas of law in one act. So you can bring it all together. Often we use the word consolidate when we're talking about laws being brought together, Consolidation Act. And this makes law simpler. So a really good example is the Fraud Act, which brought all of the offences on fraud into one single act. Whereas if you think about judges and what they do, they make minor adjustments on points of law, on certain bits of law in certain cases. So it ends up being scattered all over the place in common law, whereas the big advantage of this legislative process is that they can put it into one act, so it's really simple to follow, and they can bring all of the law just into one place, which makes it easier for students to learn, for lawyers to use, for judges to apply. But saying that, Parliament really lacks a lot of time to focus on lots of this big reform, particularly around technical reform, which is things to do with like criminal or tort law. They generally focus on broad policy and things like that, rather than specific pure law or technical reform law. So they often won't spend the time on that, either because they don't want to, because they need to focus on other things. Often we describe that as them lacking their political will. There's no benefit to them necessarily in doing that as a focus. Certainly if you go and knocking on people's doors saying, what they want to, why they're going to vote for you, not many people would probably say, well, I want you to reform criminal and tort law in this particular very niche, unique fashion. They're more interested in things like the economy and unemployment, immigration perhaps, or education, NHS, those sorts of things. So a good example of something that clearly hasn't been reformed is the Offences Against the Person Act, which you study on the A-level for this, 1861. Obviously it's really old, it's in dire need of reform. You possibly will, if you haven't already, will evaluate and look at that as an essay. And the Law Commission have come up with lots and lots of reform suggestions for this, but Parliament haven't implemented any of them. So it remains the law as it is today. So it's a really good example again of something that they could actually reform all of that law in one go, but they've not. So yes, you can do full reform, but they don't tend to do it with technical reform. Moving over to the other advantage on broad policy. So nowadays, new acts really generally set out the broad policies of the law, so the broad idea of what they want, and they often then give powers to others to make laws, so delegated legislation. So they'll then put the detail into what that law actually looks like, and that's really good because MPs don't necessarily have the expertise, so it allows other people to put the expertise in there and the specific detail and knowledge. Certainly our MPs can't know all that, so it's a good way. They set out the broad policy, the main objectives of the law, the main sort of restraints and limitations that they're happy with, and then other people fill in the detail. So setting out the sort of basic structure. And that's very different to how laws used to be done in Victorian period. In the Victorian period, laws were very detailed, very specific, down to like if you think about OPA as a good example again, it had lots and lots of very specific offences, and the old Larceny Act before the Theft Act was very similar to that as well. So we don't really do that anymore. One of the big problems with this process again though is you can do the broad policy, but actually they end up being very complex. So they can be very long and very detailed. They can be difficult to understand, and for instance many Supreme Court appeal cases are actually to do with the interpretation of acts. So you can clearly demonstrate there that there's disagreement even at the highest court of the country as to what certain things mean within the Acts of Parliament. And where obviously Parliament gives powers to other people who are experts, perhaps through the delegated legislation process, again this can make laws really complex and difficult to locate, as they can be in different places. So it's not as easy as it certainly seems. The final advantage of this legislative process is consultation. So there's a really clear process of consultation in this process, starting with the Green Paper, where they go out and ask people. So for instance, we looked at in the previous slides around the same-sex marriage bill, for instance. And that allows people to have the sort of democratic chance to comment on new laws, influence changes to the law, make sure that these new laws are actually going to be effective in what they're setting out to do. And then obviously, as that's the consultation with the public, they then go through a very deep consultation within the houses as well, both the House of Commons and the House of Lords, with ample room for different opinions, suggestions for amendments, and really lots of debate. The problem with all of that, moving across the disadvantage, is that it's a really long process. Passing legislation can take months, even years in some instances, and actually they can be altered throughout the entire process. So what you end up with might be very different to what was originally intended once you go through all the amendments and those stages, going through the House of Lords, etc. So, and that that isn't this process isn't great for times when you need emergency law through. So think about COVID-19, think about sort of issues of perhaps like terrorism and warfare, etc. This legislative process takes too long to do those sorts of things, or to wait for that. So often they'll have to go through the delegated legislation process instead for where there are areas of sort of security or national interest or emergencies. Okay, thank you very much. I hope you enjoyed that video. Please subscribe to the channel, it really helps, and there'll be more videos coming soon. Thank you very much.